Let it be acknowledged that our Prime Creator is here and present. We ask that the words spoken here are heard and felt as they are our true history. We pray that what is spoken here is taken to heart as sincerely as they are spoken, and that we may continue to learn and to educate others as to the importance of our relationship with our Creator, the highest law of the land, of air, and of water. That is law, land, air, water. That of air, the heavens, being the core of law and the most integrous of all law forms. In so doing, it is possible for those in positions of authority to sort out with whom is their loyalty, to whom do they give their allegiance in their work or position of influence. We offer this in integrity and pray that it be respectfully accepted with the sincerity and critical importance with which it is shared here today. Let it be so.
Hello, this is about incontrovertible evidence. What we're dealing with on Oregon. On Oregon, we have, can you see that one? The Bill of Rights. Most everybody knows about them to some degree. We also have a transcript of the Articles of Confederation. Actually, it's the Confederation and Perpetual Union's articles, but I digress. Then we have the Constitution of Oregon. Mine is dated 2011 edition. And I got this from the law library in Washington County. And in it, we have what the legislature of Oregon provides. That's who's responsible for this. And they get their information from the Secretary of State. And in it, we have Article 7 amended, the Judicial Department. That was put into the Oregon Constitution November 8th, 1910. There is no evidence available, nor has there been for the last 8 years, that that was placed into the Constitution properly. Then we have you got that one? Article 7 original, the Judicial Department. I'm showing you this so that you will know I'm not just talking. All this stuff is written down. If you read it, it's there. Then we have my copy of this. The Constitution of the United States, a transcription. But it's brought to me by right there at the bottom, the archives.government. And in there is our codified guarantees of all of our unalienable rights. That's the stuff we're supposed to be absolutely sure is ours. Then we come to Article 3, Section 1. That goes over onto another page where you'll see there's an Article 4. So it's not all that long. And the Constitution of the United States of America is a document owned by the several states in Congress assembled as the United States of America. That is an entity. That entity has a contract with the United States of Washington District of Columbia, a government management company is about the best you can come up with. And it manages, or the military manages it. It manages forts, ports, and military facilities such as armories, territories, needful buildings. And on Oregon, where we're discussing now, we have a need for the Oregon Constitution to honor Oregon's commitment to the United States of America as one of the states to uphold and defend and to honor the Constitution. And they did so. They supplied all of the other states with Oregon's Constitution. And we could read in all kinds of documents from Buchanan and other places that there really was a vote taken in Congress, and Buchanan signed it, and Oregon became a state. In that case, there is a contract. There is a contract between the United States of America, which is all of the several states, 32, stopping with Minnesota, agreeing to take Oregon into the Union with all of the benefits and privileges of one of the original 13. No difference. An absolute equal. So that group holds a contract with a group called the United States, which is made up of 3 separate divisions: the executive, legislative, and the judiciary. And we had that government from, let's say 1775, before they ever got going, they were doing it. From 1775 on through the first iteration of the Constitution, the inauguration of Washington, and on into making Washington a district, a federal district, but it wasn't federal, not yet. It was a confederation. When they formed their confederation and perpetual union, they rejected federal. They knew what they were doing, and they elected to become a confederation. And so they did. And that confederation welcomed Oregon. So there's the United States of America's Constitution, which Oregon must comply with, and Oregon's Constitution, which we have evidence that it did comply with the Constitution of the United States of America, and they sent it back to Oregon. However, we cannot find it. We cannot see it. We've talked to the offices of 5 secretaries of state, both parties, and 3 deputy secretaries of state. And the state of Oregon, AKA all caps state of Oregon, has not been able to support their stand that they are the legitimate government. The legitimate government could provide their statehood documents. So then the statehood documents of Oregon has to be in the National Archives in Washington, D.C., or the Library of Congress, or wherever they store the other 32 constitutions of the several states, because Oregon was the last of the several states. If you take a look at Nevada's constitution, I was born and raised there mostly. Nevada's constitution does not qualify it to be one of the several states. It's a federal state of the federal martial law organization operating out of Washington District of Columbia, Inc., in some form that I don't know and they won't fess up to. But that is an entity that is not the United States. The United States ceased to exist at the same time the United States of America ceased to exist as an active government. They became inactive due to various reasons. And a coup happened, March 1861. It took a while for the whole thing to work its way through. It ended when Lee and Grant signed an armistice. And we had martial law everywhere. It was martial law. And it was masquerading as a constitutional republic, like we had when Buchanan, the last legitimate president of the United States, then we got Lincoln, the first illegitimate president of the United States of Washington District of Columbia, Inc., in some de facto color of law form. They lie to us. So then we have a form of martial law in all of the states and territories. And then Ex parte Milligan came along in Indiana, and that says that if there is a civilian common law court of record on the land, there cannot be martial law. So they did away with all of the courts and made all of the courts illegitimate, de facto, and part of the coup. And they doubled down on that in Bukini 303. They hid Article 3 so that you can't find it. And when you find it, they will not claim original jurisdiction. An Article 3 court, the only court where a man can find remedy against the state, is found in Article 3. Then they make that court impossible to find. And they run you in and out of an Article 1 or some special court where they can do whatever they wish to do, and they do it with attorneys. And they have a special attorneys club, and we're not in it. And they disregard the Constitution. And every once in a while, SCOTUS, which is a member of the United States of Washington District of Columbia, Inc., that bunch, they act like they are from the United States before the coup, and they make some strange calls. They recently made a strange call in that SEC versus Jarcasi 603 US 109. The Fifth Appellate and SCOTUS agreed you have to have an Amendment 7 court because the SEC must comply with Amendment 7. Now, Amendment 7 in suits in common law. Now, when the Fifth Appellate and the Supreme Court were talking about SEC Jarcasi, they were talking about juries. SEC didn't have a jury, didn't have a proper jury. A proper jury is 12. So in suits in common law, now we can't have, as men and women, suits in anything else. That's why we have Amendment 7. We are not subject to admiralty or maritime law. We are not part of he who can be deceived, let him. We are part of the bunch that is in Article 7 original before they ever made the bogus amended. So the bogus amended Article 7 in Oregon's Constitution clashes in the first few words with Amendment 7 in the United States of America's Constitution, where you cannot clash. I recently read that SCOTUS had made the decision that all of the carry permits in all of the states were unconstitutional. Why, of course, we found that on Oregon in 2017 and notified the legislature and all 36 sheriffs before we even had a court. That's not news. That's just part of Jural. It's there. All you have to do is use it. You have to do it yourself. Nobody can do it for you, and you can't do it alone. That stands for me and you and the sheriffs and all the rest of the elected people that we're dealing with. The other day, in 2 other days, I was talking to 2 different county commissioners. And one of them said to me, "You're a troublemaker." I said, "Yes, and I'm disruptive. And I have been deceived and defrauded for 115 years. And you're part of it. What do you expect from me? I'm going to oppose you at every turn you make that is incorrect." Your next move is to determine whether or not you want to commit misprision of felony, or you want to require your sheriff to comply with ORS 206. We'll either have a proper sheriff and a county commission that is doing their job, or we change all four of them. That's all there is to it. Now, the way that happens is if you cannot defend your position, you fail. Not one sheriff can defend serving Article 7 amended. And the reason for it is they all know enough about law that if you cannot support your claim, you fail. And the state of Oregon, AKA all caps state of Oregon, cannot, has not, will not support their claim of Amendment 7 of Article 7 amended. That's just how it is. They can't do it. They haven't done it, and it can't be done. Therefore, our sheriffs have to know. Any reasonable person would understand. First person singular of people. They'll understand that when this is presented to you and you ignore it, you have failed. And the sheriffs know it, and they ignored it, and they failed. So now what is the sheriff going to do? That's his decision. He's either going to abide by what's lawful, what's legal, what's right, what's correct, or not. That's not for us to decide and determine. That's already been determined. He either complies or she complies or they don't comply. But there is no opinion. Opinion doesn't appear anywhere. We have the written contract, the United States of America's Constitution, and a facsimile of Oregon's Constitution, circa 1859. And we have Bouvier's 6th edition law dictionary. There are no opinions. It's written down and it's identified. It has a definition. I went online today, another time, with one of the AIs. They're not AI, they're a program. And they're basically stupid. They'll lie right to you like you can't read. They'll tell you something, and then in the next iteration of their regurgitation of lies, they'll tell you a tiny bit of truth and then lie again. And when you catch them in the lie, they'll say, yes, you're right. And then they'll lie again. And people write stuff up and use that to submit. To whom? On what? That's a program that's been proven to lie. And you're submitting paper with something like that. No, you write your own paper. And if you're not smart enough to write it, get somebody to help you. Counsel, unfettered counsel. That doesn't mean an attorney member of the bar, or a lawyer that's a member of the bar. If they have an oath to the bar association, then they are fettered. They cannot be your counsel. That's all a lie. And it's a lie starting with the Oregon Supreme Court, the Appellate Court, and all of the state courts in all of the counties where there's supposed to be a county common law court of record that complies with Article 3, one Supreme Court claiming original jurisdiction. Article 7, Amendment 7, in suits in common law where the value is over $20, it takes a jury. Courts judge the law, not judges. Courts judge the law, and juries decide the facts. I yield.
Hi, my name is Charlie White. I'm with the Oregon Statewide Jural Assembly. We've been working for quite some time, connecting with our sheriffs, or at least trying, to encourage them and actually require them to take a proper oath to the proper constitution with God and the laws of nature included. So this is my first appeal. Where are our sheriffs? Article 3, Amendment 7, Civilian Common Law Court of Record has made numerous visits and relentless communications to our county sheriffs on Oregon. Why? Because our sheriffs are our first protection against governance overreach. It is our county sheriffs that should be there to assist seniors to prevent their eviction from their home and all they possess. It should be our county sheriffs who protect and defend the people from a corrupt court system, rather than ticketing them or supporting the illegitimate amended Article 7 courts. Our sheriffs seem to be avoiding any engagement with us, the people reaching out for a conversation about their refusal to see us. Contact requests are met with cricket sounds. Where are our sheriffs? It is significant that they take a proper oath to the Constitution circa 1859 with its original jurisdiction. It's a necessity. That is to the people rather than to a corporation, and to our Creator, that is, with God included. Such a dejuration, an oath, is needed for there to be remedy in our system of governance. Let's get this ball rolling. It's just taking one of you to make a difference. It gets it started to assist in awakening your colleagues in sheriffdom. Let it be so.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying. Then he jumps out of the car. And he's got both his hands up. And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, to shoot me. And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, they shot him 3 more times.